All right, this is docket 25-1892 FC, people of the state of Michigan versus Enrico Brooks, and the jury indicated, I don't know, I think it was about 9:30 to Brian Ring that they had a verdict, everyone's been assembled, everyone is present in the courtroom. The counsel for each side, lead detective and defendant. I've already made a record of the request that they wanted the paper evidence, and we had a correction on the verdict form. I don't think there's anything else to make a record of unless either one of you wishes to do so.
I don't believe so, Your Honor.
Nothing from the defense, thank you.
All right, we'll call the jury, and then afterwards, if counsel would join me to thank them, that would be appreciated. The jury, please.
All right.
Good morning, thank you, you may be seated. I told you when you would return, I would ask if the foreperson was chosen, and if the foreperson could please stand. Juror 8, you are the foreperson. And was the jury able to reach a verdict on all 18 counts?
Yes, Your Honor.
In a nice loud voice, please read each one individually into the record. Thank you.
We the jury find the defendant.
Nice and loud.
Sorry. We the jury find the defendant on count 1, torture, guilty. On count 2, assault with intent to do bodily harm, less than murder or by strangulation, we find the defendant not guilty. On count 3, assault with intent to do bodily harm, less than murder or by strangulation, we find the defendant guilty. On count 4, assault with intent to do great bodily harm, less than murder or by strangulation, we find the defendant not guilty. On count 5, assault with intent to do great bodily harm, less than murder or by strangulation, we find the defendant guilty. On count 6, domestic violence, we find the defendant guilty. On count 7, home invasion of the first degree, we find the defendant guilty. On count 8, interfering with a crime report, committing crime / threatening to kill or injure, we find the defendant guilty. On count 9, assault with a dangerous weapon, we find the defendant guilty. On count 10, felony firearm, we find the defendant guilty. On count 11, interfering with electronic communications, we find the defendant guilty. On count 12, aggravated assault, we find the defendant guilty. On count 13, criminal sexual misconduct of the first degree, we find the defendant not guilty. On count 14, using a computer to commit a crime, we find the defendant guilty. On count 15, personal identifying information, we find the defendant guilty. Count 16, intentional dissemination of sexually explicit visual material, we find the defendant guilty. On count 17, weapons, firearms, receiving and concealing, we find the defendant not guilty. And on count 18, felony firearm, we find the defendant guilty.
Thank you. Would either counsel like the jury poll?
No, Your Honor. Yes, please, Your Honor.
Thank you. Jurors, you've heard the verdict on each count read by your foreperson. I will now individually ask you 2 questions, and I need an answer to each question. First, was the verdict that was read on all 18 counts your individual decision? And second, was it the decision of the whole jury? Juror 1, how do you answer each question?
Yes and yes.
Juror 2,
Yes and yes.
Juror 4,
Yes and yes.
Jurors 6,
Yes and yes.
Juror 7,
Yes and yes.
Juror 8,
Yes and yes.
Juror 9,
Yes and yes.
Juror 10,
Yes and yes.
Juror 11,
Yes and yes.
Juror 12,
Yes and yes.
Juror 13,
Yes and yes.
Juror 14.
Yes and yes.
Thank you. As to sentencing, we are going to do sentencing September 9th at 10 a.m. Sir, that means that you will need to cooperate with probation. They're going to come and see you. They're going to do a very detailed pre-sentence investigation report. And we'll all discuss that at the time of sentencing. I take it that date meets with both council's schedule.
It should, Your Honor. Yes, that would be fine. Thank you.
All right, sir, you are remanded to the Ingham County Jail until sentencing. Is there anything else we need to address on behalf of the people?
Not on behalf of the people, Your Honor.
On behalf of the defendant,
No, Your Honor.
I just remind you to collect your evidence, and we will rest on this case, and I will invite both counsel to come to the jury room and personally thank the jury along with me.
Thank you.
That is all for this record.
All rise.
Just sit back in the room and read it.
I cannot talk. Is there a time I can play that? Okay.
Just sit back in the jury room.
Just a verdict on the jury, and then I'll play back. Thank you. All right, counsel, please join me. Students, you may protect your. date the district court gives, we'll deal with everything. Is that acceptable to you? On behalf of people?
Yes, Your Honor.
Okay, so I'm just gonna make a note that to schedule all matters if the new one comes up. Okay, and then you'll talk to him about coming in and all that. Okay, thank you. So which case are we ready on?
We're ready on Devon Cheney, Your Honor.
I don't see her on Zoom yet, guys.
Which case are you on?
Ashley Person.
Okay, what about Ashley?
I don't see her on Zoom.
Is Ashley?
I'm sure a lot. I don't know, it's past 11.
You'll see. Can we do Ashley first?
She's not on Zoom.
Okay. Is she? Okay. Is she supposed to be on Zoom?
Yes.
She's scheduled at 11 o'clock. It's what, 11:21. So can you reach out to her? Or, she's in, because it's MDOC.
I'll email the facility. I have.
Okay,
They
yeah,
can
grab
grab
her
it.
on the email, okay. Okay, let's do that. All right, this is docket 24-1007FH, people of the state of Michigan versus Devon James Cheney. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Bucks on behalf of the people of the state of Michigan.
Good morning, Your Honor. Everyone for Mr. Cheney, who's on the side.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you had enough time to speak with your attorney?
Yes, ma'am. Yes, Your Honor.
Have you taken any medication yesterday or today?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Are you supposed to be on medication you're not on?
Yes, Your Honor.
Is it anything that would interfere in your ability to understand your attorney or this court?
No, Your Honor.
And sir, you have an allegation here that reads, you should be held in contempt for failure to report to pretrial services as directed and that's for a pre-sentence investigation report after you pled, and you pled to.
Right.
Well, I guess, did you plead? I don't have-
Yes, Your Honor. He pled to the possession of narcotics less than 25 grams.
Okay,
And that was back on November 20th of last year.
okay, thank you. So you pled guilty to possession of a controlled substance known as cocaine, punishable by 4 years and or $25,000, and you were directed to meet with probation for a pre-sentence investigation report. It appears that you failed to report, and so we cannot proceed to sentencing. Furthermore, it appears that there is a new crime that was committed while you were released. Where is that in the system?
We're having a probable cause conference this Friday, Your Honor.
Okay. So I'm going to, even though it's written as one, I'm going to make this as two allegations, failure to report to pretrial services for PSIR, and then count two, committing a new crime,
Allegedly, Your Honor.
allegedly committing a new crime. And so, count two will be held in abeyance. Actually, I'm just simply going to dismiss count two. And we'll deal with that when and if that comes up. So it would be count one, defendant failed to report to pretrial services for pre-sentence investigation report as directed. And is there any objection to that amendment?
No, Your Honor, thank you.
All right, on behalf of the people, any objection?
No, Your Honor.
Thank you. And counsel, are you waiting for the arraignment?
I do.
Will there be a plea or a hearing?
Okay.
Sir, you'll be pleading, are you going to be pleading for failure to report to probation for pre-sentence investigation report?
Yes, Your Honor.
Okay. You understand what the allegation is?
Yes.
And you understood that you were supposed to go to probation so that we could proceed to sentencing with that report, and you failed to do that. Is all of that correct?
Yes, Your Honor.
And are you pleading of your own free will
Yes, Your Honor.
after you spoke with your attorney?
Yes.
And you've been satisfied with the representation of your attorney?
Yes, Your Honor.
How do you plead to count one, failure to report pretrial services for a pre-sentence investigation report as directed?
Guilty.
Thank you. And is there any reason why you couldn't show up for that?
I called and I must have missed the call back for the date to come in, and that's how it happened, honestly.
Well, sir, you understood that was
For the new case.
it was for this case, and it was your responsibility, correct?
Yes, Your Honor.
And you should have followed up. You missed the date, you rescheduled, you understand that?
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, understanding made. He's now held in contempt for failure to appear. We can't proceed without this, and that had been explained to him at the time of the plea. Therefore, everyone will enter on behalf of the people. What would you like me to know?
Yes, Your Honor, this is the second time that Mr. Cheney has failed to appear for the pre-sentence investigation. We've also now set sentencing now twice, and he has failed to appear to sentencing on both dates, Your Honor. At the prior sentencing on the prior sentencing date on May 13th, that the defendant was given at the bench warrant arraignment back in March. His attorney at the time, David Carter, had filed a motion to dismiss or motion to withdraw, which was granted by Your Honor. At this point in time, Mr. Cheney is a flight risk, Your Honor. He's failed to appear twice now for a pre-sentence investigation and has picked up additional new charges. Therefore, Your Honor, I believe that it would be appropriate to keep Mr. Cheney in custody until the time of the next sentencing date. So he can make sure to get that PSI done, and he'll be present for that next sentencing date. Thank you, Your Honor.
Counsel?
You know, I saying that Mr. Cheney is a flight risk, I think that's overkill. During the time that he failed to appear in court, he went to school. He's graduating in 2
In the
weeks.
next couple of weeks, I'll walk the stage.
So.
Sir, don't interrupt her. I will turn to you in just a moment. Ma'am, would you please continue? I just can't have the court reporter have both of you talking at the same time. Thank you.
So he's going to be graduating from LCC soon in 2 weeks. He also was able to have a child, which is a good thing. His child is going to be will have her first anniversary in 2 weeks. He is going to therapy. I think that was one of the requirements last time from the court, because there was the need for him to get some healing after the passing of his father. That's one of his struggle. So he went to therapy. I do believe that he's ready to take care of everything that has to do with the criminal justice. We will respectfully ask the court to give him a tether or put him on house arrest, so that he knows, the court will know where he is all the time. He can take care of his family. He can go back to school. He can graduate to school from LCC and get back to be a productive citizen. Sending him to jail, letting him stay in jail while he's waiting for this, it's counterproductive. Plus, he had already spent a lot of time in jail previously. I think that he had 156 days in jail for a possession of less than 25 grams of controlled substance.
What are the new charges, counsel?
The new charges are
Resisting obstructing?
Yes, yeah.
Was that the only count we have for people?
I'm seeing a resisting obstructing as well as a fleeing in the 3rd degree, Your Honor, which once again shows that Mr. Cheney is a flight risk.
All right, sir, what would you like me to know?
I would like you to know that I am supposed to be walking the stage here in a few weeks. I did
You're
graduate.
supposed to be what, walking?
Walking the stage at LCC here in a couple of weeks. My daughter's birthday is next week, unfortunately. And that's kind of what led to everything that's going on. I'm low-key avoiding jail. So I could attend my daughter's birthday and stuff like that, and attend walking the stage, because I never did it before, but it would have meant a lot to me to be able to do that.
So you want me to respect your graduation and your daughter when you disrespected law enforcement, this court, probation, and everybody who's trying to help you? I'm confused. Why should we respect you when you have not respected us? Do you have an answer for that?
Your Honor, unfortunately, I've been just going through stuff, and I ain't been learning. I'm learning how to cope with it, but I honestly didn't mean to take it out of your courtroom or you. No, in no disrespectful way. I know what it looks like and what it seems, but
What it looks like is I got a whole file of, let me see, we should be held in contempt for failure to appear for the updated pre-sentence investigation report I signed February 4th. I keep letting you out, you keep disappointing me. And we already had defense counsel withdraw, I appointed you attorney, you failed to report again. I mean, what is it you're not getting? You want me to give you multiple chances, but you're not following through.
and I want to honestly respect that. And if we,
When are you walking, sir? What's the date of your graduation?
June 21st,
Okay.
and more than anything, if I could, even if I had to, tether or house arrest, whatever, or turn myself back in, whatever. I want to get this stuff over with too, so I can proceed with my life, because it's causing, honestly, a lot of trouble. By any means, that is not my objection to run or be flight risk. That is not the case.
But you are, that might not be your objection, what your goal is, but that's exactly what you are, is a flight risk and disrespectful. Let me just tell you, you got a 1-year-old, right?
Yes, ma'am, she's here today.
I don't know why she'd be in the courtroom, but that's fine. Here's the thing. If there's some kind of accident emergency, who do you think is responding? Law enforcement. Along with whatever other emergency services you need. They might be detained by someone just like you, which could mean life or death to your daughter. That's what happens with all of us. When you fight with law enforcement, they cannot respond to other emergencies that are life and death. And you put yourself at risk, you put them at risk, you put others in the community at risk. Have you ever thought about that? You have, then why are you doing it? Because you haven't thought about it, sir. Don't lie to me. You haven't thought about it. What you've thought about is me, 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 me. You have not thought about your community. You have not thought about your daughter or the mother of your child or your family. Your actions speak louder than your words to me. Get your act together. Here's the deal, sir. You will leave that jail at some point. If you want to, take a mini-me outfit for your daughter. How does that sound? Horrible? Exactly. But you see, you can talk to law enforcement, you can talk to your attorney. You don't have to believe me. We see generations, because once dad or mom commit a crime, kids think it's okay. They think it's really cool. It's not cool to be in there, is it? No. So flip the script, change the song. If you want the dance to change, the music has to change. The only one that can change that is you, sir. Follow the rules. You're going to be raising a daughter and put rules in place for her, right?
Yes, ma'am.
Okay, so when she violates those rules, what are you gonna do? Say that's okay? What are you gonna do?
Penalty.
Some penalty. Exactly. Well, that's what's happening here, sir. So I'm gonna tell you what I'm gonna do in just a minute. our next hearing in this matter?
Your Honor, there is none at this point, as the defendant failed to appear for sentencing back on May 13th.
So we've got this other case coming up, and that takes what, 4 weeks, 6 weeks? How long are they taking these days?
Around 4 to 6 weeks, Your Honor. I will say, looking at the dates, it is set for a preliminary examination next week on the 18th.
Okay.
And it's set for a PCC this Friday, Your Honor. Obviously, it would go quicker if Mr. Cheney waived at that point in time, but obviously I'm not telling him what he wants to do under his rights. I'm just.
Okay. All right, so I'm gonna reinstate your bond, but you're not getting out today. You'll be released June 20th, so you can walk. I think that's important. Whether you celebrate your daughter's birthday after that, it's up to you, but you're not gonna be out here for the birthday of your daughter. That is too soon. She's not gonna know whether you're there or not. Sad that you won't be there. But that is part of your consequence. You will be released on a jail GPS tether. And that means you have to charge it and you have to show up. We're gonna know where you are and what you're doing. And all the other orders remain in effect. I don't think I need to go through them. No drugs, no alcohol, no crimes, no guns, no weapons, etc. You understand all of that?
Yes, Your Honor.
You'll appear for all hearings and proceedings. The next court date is July 29th at 10 a.m. Your attorney and the prosecutor can move that if we don't have all of your matters able to be set at the same time. I like one-stop shopping. At this point, you're wasting time on my docket. You do it again. I don't care if you're walking to the White House and gonna shake the president's hand. You're not gonna show up for that. You're gonna be in jail. So do what you're supposed to do, because I won't let you out again. I do think it's important with everything you're going through that you walk. You earned that walk. And I hope you continue to accomplish good things in your life and to honor your family doing that. I know you're grieving. I know that a lot's going on in your life, but the only one that can change it is you. And you need to honor those people you've lost by doing great things here, not by failing. You need to honor your daughter by showing her, yes, you can make a mistake, but you can learn from the mistake and do better. And respect law enforcement. Their job is horrible. Just remember that they are the ones who save your family's lives when you're not there. Don't disrespect the uniform. And if you feel disrespected by them, there's a remedy. So we all have to live and work in this community and partner together. You need to be part of that partnership, because if you are not, the jail or prison await you. Have I been clear, sir?
Yes, you have, Your Honor.
Do you have any questions about what I mean?
No, Your Honor.
So if probation has not come to see you, and I'm going to put a court note to ask them to come see you while you're in lockup, then you have 24 hours after your graduation. So by the 22nd, you will make an appointment with them and keep it. Failure to keep it, I have a standing bench warrant. I don't even need to re-sign it. Law enforcement's gonna pick you up. They know where you're located. they'll find you, you'll be untethered. If you cut the tether, that's even a bigger felony. And you'll owe a whole lot of money because they're expensive. Do you have any questions?
June 20th.
We're gonna give you a paper July 29th at 10. And you're gonna be released June 20th, so you can walk.
Appreciate you, John.
I will appreciate you if you follow these orders. So this is not, jail's a punishment. These orders are not a punishment. It's so we can get you on with your life and we can have a safer community. Show everybody that you're worthy of all of these chances. Most important, your daughter. Someday she's gonna be able to go on the internet and look at what you did do or you didn't do. And you're gonna have that tough conversation saying, yeah, I screwed up, but you know what? I made it better.
And that's for it.
Okay?
That's fine.
How many days has he been in jail? Because I have 270 or 253 days, and then he's gonna get credit for all of these days. So the jail can figure that out.
I think he was.
You're running out of jail days, sir. You get 365 days jail. And once you're out of that, it's prison, and you got 4 years. So let me just tell you, so that you have this as a reminder. So 4 years is 48 months. I could sentence you to 32 months to 48 months. How's that sound?
Not good at all.
So then you'll be there when your daughter's going to preschool, maybe kindergarten, and she won't know who you are. You got a lot to lose and everything to gain by doing the right things. Good luck to you, sir. Make sure you get your paperwork.
See you July 29th.
See you then.
Gotta be safe. Later.
We do have this person on Zoom now.
All right, let's get to them because otherwise,
Like 10 seconds, please.
11 days, no credit.
he's gonna get credit, I just don't know how many days. Because he's gonna get credit for all of these days plus up to the 20th.
Right, but for the contempt judgment, as far as today goes.
He has been in custody for 11 days.
He's been 11 plus whatever the 20, up to the 20th is.
Okay, so it'll be 22, 11 days credit. Because it's 11 days from now until the 20th.
So, yeah, he'll be released on that day. Not earlier. So we're not counting the jail credit. We're not doing the, not to be released till the 20th, so however they count. Okay?
Your Honor, I have your next case. It's People versus Ashley Person, case number 21-594-FC, set for defendant's motion for new trial. This person is on Zoom and her attorney is present here in the courtroom.
Thank you, counsel. Your appearances for the record.
Elizabeth Allen on behalf of the people, Your Honor.
And Mitch Foster for Ashley Person. Good morning.
Morning. This person, I don't know that you'll have anything to say in this. If you do, then we'll swear you at that time. The record should reflect she is here from the Michigan Department of Corrections via Zoom. And counsel, we're all in agreement that she appear in Zoom and not next to your side.
I will waive her presence in person for purposes of this motion hearing.
Thank you.
If there is an evidentiary hearing granted, then I want her in person.
Absolutely, we'll deal with that at that time. If you could make your arguments at the podium, please, you may proceed.
Thank you. I believe, Judge, I coherently made the arguments in my motion and brief.
Yes.
I also submitted supplemental authority. It is an unpublished case, but in in the balance of the prosecutor's unpublished authority, I think the court should be looking at all of the unpublished cases cited by both sides.
Thank you.
So in this case, Ashley was, and her attorney, most importantly, clearly argued accident, but never requested the accident instruction. And her attorney never objected to the prosecutor's statements about bringing a gun to a fist fight, which is directly contrary to her right, which she stated that it was her right during trial, during her cross-examination. So the prosecutor argued that the right to keep and bear arms for self-defense under both the Michigan Constitution and the Second Amendment were specifically what caused a high risk of death or great bodily harm. Now, the prosecutor could have argued that when she drew her gun and how she handled it was that.
You're trying to go for self-defense, huh?
Whoever keeps, why is that being allowed? Whoever that is, I'm gonna bench, if anybody wants to chime in here, I will send law enforcement with a bench warrant. Who's up now?
Okay,
Thank you.
Okay.
do you want me to tell you where? The prosecutor could have argued that when she drew her gun and how she handled it was that.
Was what was the prong on the second-degree murder of creating a high risk of death or great bodily harm. Not that she merely possessed it on her hip, and not that she walked outside doing everything according to the law before the physical confrontation began. So I think that was, and that was not objected to. So that's where I'm arguing ineffective counsel for the failure to request this instruction on accident and the failure to object to the prosecutor's characterization of what she did to create a high risk of death or great bodily harm. Like I said, if he merely argued how she handled it, that would have been proper and under the law. But arguing that she brought a gun to a fist fight, he said that multiple times, was improper in violation of her Second Amendment and Michigan constitutional rights. Now, the evidence at trial in support of the accident instruction were that the DNA on the gun was 3 to 4 times more likely to come from Leanne, the decedent, than any other stranger. So the prosecutor in her brief seemed to downplay that as whatever the terminology that experts use in terms of this, the weight of the significance. But when you're arguing to a jury that it's an accident, or even to the judge to get the accident instruction, 3 to 4 times more likely is a very significant evidentiary value and should have been argued. And also there were, to support of the accident instruction, multiple people heard Ashley say, it was an accident, what did I do? And Ashley herself testified that yes, it was an accidental shooting. She didn't have an intent to shoot the gun, she didn't have an intent to kill.
But I think, counsel, that's why the jury found second degree. And as I recall the testimony, the weapon was pointed directly at Leanne's face, and then it was fired. And even if she didn't intend it, it's a dangerous weapon having that ability once you put yourself in that situation. And she came out, she was in the safety of her home, and she came out blazing guns, so to speak. What would change? What would change, sir?
Judge, I believe that that's a fair inquiry. However, the evidence was undisputed that when she came out, the gun was at her hip and it was not drawn. And that when she came out and these people confronted her, the gun was not drawn. It was only drawn after she was not the aggressor. It was only drawn after she testified she got hit in the head or something. She didn't know which of the 3 sisters did. I don't think she thought it was the decedent. I think it was one of the other 2. But it was only then that she drew her gun. And then when the gun was, during this process, there was not just her holding the gun. Of course, it was where it was pointed, it was all, she testified, it was self-defense. But if you have someone, there was testimony that the gun was batted by Leanne, the decedent, or Ashley said it was grabbed. And during this pulling, her finger, unfortunately, was on the finger, and the pulling contributed to the discharge. And she said she reflexed. That was her testimony. So that's clear evidence that it was an accident. And I understand what the court's question and inquiry is, and I understand how the prosecutor argued. Just going out there created the unreasonable risk. It may have, I can't even say it contributed. It contributed to the facts of what happened, but merely going out there until she actually drew the gun, there was nothing that she did that created the risk.
Until she holds the gun, and I think the jury discounted her testimony of whether or not she needed to do that, because you can claim accident all day long, but ultimately, even if she didn't intend it, that's the natural consequence of bringing a gun, and she knew it.
I strongly disagree with that
Okay,
determination, because
I mean,
There was
from
no-
what I heard, as well as what the jury saw and heard.
right, there was no natural consequence. The defendant actually did not put this process in motion of a physical altercation. She showed up, and I believe her testimony was she was worried about her boyfriend. He might have been intoxicated and had a gun. She was worried he might do something, and that's why she went out. But regardless,
You
I mean,
call
you can-
911. I mean, the problem is she went with that gun and then pulled it, and he was handling things himself. I
agree that, Judge, if things could have turned out differently, and if she didn't leave the home, this most likely wouldn't have happened. But once you're there and you're not committing a crime, you're doing, you can argue all you want whether it was proper judgment, maybe a civil case of some sort of negligence. But when you actually are not doing anything wrong and you only draw your gun after you've been hit and after and then the discharges after someone's hand is on the gun, that's a whole different scenario. So, but I think the court's getting at is prejudice, because I don't think there's any dispute that the defense was accident. So, and the defense attorney didn't ask for the accident instruction. And I don't think there's any dispute that if you leave your apartment armed with a gun, open carry, and you're not a felon or have a domestic violence conviction, you are acting within the law. So those are the two things that I have issue with defense counsel. And I think when you were skipping ahead to prejudice, and I appreciate that, but I think we have to establish that it was deficient conduct not to ask for the instruction. And then, of course, if we hear from defense counsel on what his strategic decision-making was, why would you not request this instruction? And then in your closing argument, you you say that it was an accident. That those two things, you can't have them both at the same time, unless he didn't think the accident instruction would help his case.
So
And then,
let's stop right there for a minute. I'm sorry to interrupt,
Sure.
but what there tells you there would be a different outcome? Because what we're looking for is there, if we go through this whole thing, is there going to be a different outcome in the verdict? And what is showing that?
well, I think one of the important things was you had defense counsel arguing it was an accident, she didn't intend to shoot. And then the prosecutor, of course, gets the final word on rebuttal. And the prosecutor specifically said, this is not an accident. The accident instruction was not given because it doesn't apply. I'm paraphrasing, but I quoted him specifically in the motion. So that's the final word the jury heard from defense counsel, prosecutor, or the court on accident. The final word was it doesn't apply, the instruction. So now they're told the instruction is out there, but it wasn't given because it didn't apply, and they never heard anything from the judge or the defense attorney after that. They're going to consider, well, we can't consider accident. That, I mean, that could be, so I think that goes to prejudice.
Well, let me argue this with you, because that's what we do as lawyers. The instructions clearly say, and you know this, prosecutor knows this, it's read in every single trial, that openings and closings are not evidence. So what you're telling me is my instruction that they're not consider this as evidence doesn't, that they didn't adhere to that, but they did in fact consider the arguments of counsel as evidence, and it's really how each side sees the case, that's it.
I agree that that's a standard instruction that's given, and it's often justification for when the Court of Appeals doesn't wish to overturn a conviction.
Yes.
But convictions are overturned. In the case that I cited, which was that People versus Marquise Lee Thomas from April 22nd, 2026, there was an actual, I'm sure the same instruction was given. You don't listen to my instructions, or only listen to my instructions, and what the lawyers say, you know, isn't evidence. But in that case, the instructions were, there was not the accident instruction given, and the Court of Appeals overturned the conviction on an accidental defense to a felony murder charge. So I'd like to distinguish some of the cases that the prosecutor cited.
All right, and then before we, this is just my quirk, I don't know what other judges do, nor do I care. But the case that you cited, People of the State of Michigan versus Marquise Lee Thomas, is unpublished. It's April 22nd, 2026. And that Court of Appeals number is 366840. It's a Kent County Circuit Court case. You may proceed.
Yes, thank you. And of course, that is part of the record because I did file that
Yes.
supplemental authority, so it's in the circuit court file as well.
Yes, thank you.
But as well as the prosecutor's cases are all attached to her motion.
Yes.
So, but when you look at the Bird case, I think it's the first one that she cited. This was a attempted robbery of an ATM. The defendant was clearly the aggressor on this case. So that's distinguished. And I think the language they use is if there's a force set in motion by the defendant. And so this obviously wasn't a self-defense situation where the defendant is actually robbing someone at the ATM. He can't then claim self-defense. Distinguished, Ashley was not the aggressor, and she only drew her gun after she was hit in the head by the aggressors, or one of the aggressors.
Don't you think she stood in the shoes of an aggressor when she comes and interjects herself into this ongoing situation, and now she becomes the aggressor, decide to try to maneuver people into, I guess, standing down?
I disagree, Judge. I don't see any evidence in the record that showed that she was acting aggressively. She wasn't brandishing her gun. She was merely walking out with the gun on her hip. That is clearly within her right, as she testified to. It's clearly supported by the Second Amendment and the Michigan Constitution. And the Michigan Constitution goes further than the Second Amendment. It's actually stronger in its four-year defense. It doesn't say that specifically in the Second Amendment.
Thank you.
In terms of the other Thomas case, which is People versus Darius Marquise Thomas, cited by the prosecutor, this was a case where there was some sort of a conflict. The defendant actually got out of the car. There was anyone, I think everyone was still in the car, and he fired 2 shots at the car. Clearly, accident instruction would have been a stretch, because I think he said that I think the argument was that he was shooting above the car instead of at the car. But the actual pulling the trigger there was not an accident, and that's the distinguishing fact as to Ashley's case. Now, Ashley's case, there's evidence on both sides. The prosecutor argues that she intentionally pulled the trigger. The defense says that it was an accident due to the pulling and the reflex that she mentioned. So when you've got conflicting evidence on both sides, you still have evidence that an accident occurred, and that's why the instruction should have been given. So I think it does come down to prejudice. But on the Darius Marquise Thomas case, I think the analysis suggested that instruction was superfluous and it didn't, it wouldn't have been needed. In terms of the Duncan case, this was a defendant fleeing the police going 100 miles per hour and unfortunately hitting another car or person was killed. And then the defense was trying to say, well, we need the accident instruction. When you're going 100 miles per hour, the defensive accident is not tenable. It's a force set in motion by the defendant, the speeding the car recklessly. So I think that case is distinguished as well. But really, this all comes down to prejudice, and you know, there's arguments on both sides just generally that jury instructions either matter or they don't, and it really comes down to the facts. Do the facts matter when in terms of whether a jury instruction should have been given and whether there's prejudice? And I believe the one case I cited was Ogilvy, and that was a case of a dispute with a neighbor of mowing some grass and leaving yard clippings. The neighbor confronted Ogilvy. Ogilvy drew a gun, pointed it at the neighbor. The neighbor backed away. Police were called. He was later convicted of felonious assault, but the defense counsel didn't request the self-defense instruction, or they did. It was deadly force rather than non-deadly force. So that little simple distinction resulted in a conviction being overturned because it was the wrong defense. Here, there was a valid defense, but it wasn't whether the defense instruction was right or wrong, deadly force versus non-deadly force. The situation was that a defense instruction was never even given. So following Ogilvy, that's a case where the instructions matter and their prejudice was found. So really it comes down to the facts, and I understand your position, I understand the prosecutor's position about coming out there armed with a gun. But when you really look at the law and whether that contributed in terms of creating a dangerous situation, I say no. Perhaps it would have been better if she didn't go out there, but once she's there, then you have to look at it from a different lens. Okay, if she's there, what happens next? And what happens next is what this case is all about, not her going out there.
As I recall, but what happens next is a gun where nobody else has a gun but her, and that's what I'm struggling with, sir.
Okay, let me ask you this, Judge. If she released the gun, and let's assume for the sake of argument that it's true that Leanne had her hand on and was pulling the gun away from her. She releases her gun, Leanne takes it, her finger doesn't reflex under the trigger, then Leanne has the gun. She's there with her two sisters. They're all very angry. They want to cause physical harm to Ashley, and she has Ashley's gun. Does Ashley have a right to protect her gun from being taken from somebody? I think the answer is absolutely not. Yes. Unfortunately, this is what happened, but you can say it wouldn't have happened at all if Ashley didn't come out of the home, but you can also say it wouldn't have happened at all if Leanne didn't try to grab her gun.
But you can also say she has a right to bear arms. She came out lawfully with that in her waistband or her hip or wherever it was. I forget exactly where it was, but it was on her person. The point where she decides to draw it where there are no other guns, that's what I'm struggling with, regardless of then how it the struggle ensues with the gun, she brought that into a situation where nobody else had guns. If somebody else would have had a gun, I'm right there with you. But she brought this overpowerful instrument that can cause death to a situation where nobody else had a gun.
And I may be slightly persuaded by that argument if she hadn't gotten hit in the head first before she drew her gun. That's the key.
Okay. Anything else?
Nothing further.
Ms. Allen, could you pick up from that point in the argument? I know you have a lot of other things to say, but let's talk about that piece of it.
Well, and Judge, I think where the question came in was what we're dealing with here is prejudice. And that is where the defendant's argument undeniably fails, because the Michigan Supreme Court has said that in a case where the jury has to find intent, we do not have a basis to reverse the conviction for a lack of accident instruction, because the jury had to find a specific intent in order to convict her, and they did. And in People versus Hawthorne, that is the Michigan Supreme Court, they ruled it first, where the accident jury instruction maybe should have been given. I'm not conceding it should have been in this case, and I made that argument. But because he can't meet the prejudice aspect of the ineffective assistance claim, we'll start there. And in People versus Hawthorne, where the court said, you know what, they should have got the accidental jury instruction. That case was not reversed because the jury instructions explain the intent of murder makes it clear that accident would be inconsistent with a finding of intent. So for the jury in this case to find her intent in second degree murder, which they had to do, that is inconsistent with accident. So even giving them the instruction of accident would not have made a difference because they had to find her intent. And in the cases I cited that were unpublished, People versus Thomas and Duncan, that are both in the record because I attached them to my response, both of those cases, I know he wants to distinguish them factually, but the main reason I attached them, because in an ineffective assistance claim, just like this one, both of those cases found, you know what, that trial counsel seemed to be arguing accident, that maybe was an issue in the case, and they said, we are not going to reverse because there is no prejudice, because the jury had to find a state of mind in order to convict. And in this case, they found that the defendant was guilty of second degree murder, which means they had to find she had an intent. So instructing them on accident would have made no difference. And actually, even in the supplemental authority that defense counsel just filed, the reason they actually reversed on that case is because there was a first degree murder option and second degree murder, and the trial court gave accident instruction for second degree murder and not first. And on page 3 of the case that he submitted to you, Judge, that we just talked about, the court said that is materially different from presenting a jury with options for convictions and just omitting the accident from consideration. So they are saying in the case he even just submitted as supplemental authority, if they had just omitted the accident instruction, it would have been fine, because we have the Michigan Supreme Court telling us that's not a basis for reversal. But in that case, because they gave the accident instruction only for count 2 and not count 1, that's why it's the problem. So I obviously argued from the beginning outset that it was not ineffective assistance to not request that instruction, because if you look at what trial counsel is really working with, it was not just as simple as trial counsel makes it seem. The defendant in this case admitted she armed herself. She approached a group of unarmed women who wanted to engage in a fistfight with her. And while those witnesses held those women back, she pulls out her gun, racks it, points it in the face of Leanne Hawkins, and shoots her and kills her. And the jury found her guilty of that. And when she was testifying, yeah, sometimes she kind of says it's an accident. At one point though, trial counsel says, and you had your finger on the trigger, right? She says yes. And counsel says, you obviously pulled it. And that is in the transcript. And she says yes. And the shot went off. And so the trial counsel, when he's trying to argue, well, Is it an accident? Not really, but she says she didn't have the intent to kill her. So his argument, he doesn't say the word accident. He says, I submit to you, she did not have the intent. The prosecutor has to prove intent. And trial counsel says, you know what? The prosecutor didn't prove it. Because what he is dealing with is a defendant, as I cited in the case, the unpublished case, People versus Bird, who puts all these things in motion. She arms herself, and I think as one of the witnesses says, she empties her pockets when the women show up. She empties her pocket, she brings her gun, and she goes out there. And she's engaging with them, and she has her gun, she racks it, which is a huge point. As we had from the expert testimony here also, that the amount of force required for that gun to go off, there are 3 safety measures to make sure that gun does not accidentally go off. And all 3 of those had to have been disengaged by the defendant in order to shoot. So trial counsel is dealing with all these things that she sets in motion, and she fires the gun. And also, although she testifies that maybe Leanne pulled on it, none of the other evidence corroborates that. Because the evidence is that the bullet went through Leanne's head on an upward trajectory front to back. So if someone is pulling a gun down and gets shot in the face, that is not how the bullet goes. So the evidence trial counsel is working with is that she did this, but maybe she didn't intend to. And that is his argument. And so accident, though, is a whole nother ballgame. The gun didn't just fall on the ground and go off. The gun wasn't in the mix of a bunch of people and goes off. And so trial counsel argued she didn't have the intent, and that was appropriate. But moreover, the case law from the Michigan Supreme Court and every case, even that the defendant has brought to you today, does not support a reversal, because there can't be prejudice when the jury found her guilty because they had to find that it was intentional. And I also want to address just quickly the Second Amendment argument, because counsel argues that trial counsel is ineffective for not objecting to the prosecutor talking about how she armed herself with a gun and walked out. But what that fails to acknowledge is that the prosecutor has to prove intent in every case. And the law says intent can be proven from any facts in evidence and inferred from the use of a deadly weapon. So he didn't say there was no argument, or she wasn't charged with open carrying. She wasn't, that action itself was not illegal, but the act of arming yourself based on case law in Michigan is evidence of intent, because that is something, especially when it comes to a deadly weapon, you can infer intent, and that is well established in case law. So the prosecutor actually argues that yes, she brought the gun, but he also argued she pulled it, she chambered a round, she raised it not once, but twice, 3 feet away, intentionally pulled that trigger and shot Leanne in the face, just like she told Tika she would do the week before. So the prosecutor used all of the evidence in the record, as he's allowed to do, to show that she knowingly created a very high risk of death or great bodily harm. Knowing death or such harm would be the likely result of her actions. So there's nothing inappropriate about that argument. There's no case law cited by the defendant that it's in violation of any sort of any law, and defense counsel is not ineffective for failing to raise a meritless argument. So in regards to the Second Amendment issue, there is no issue regarding that, and trial counsel is not ineffective for choosing not to raise it. But the main issue, as we've talked about over and over, is the accident. And so we believe trial counsel was not ineffective because he had to have, that's part of trial strategy. As this court knows, am I gonna really argue accident? Sure doesn't seem like it. When she went out there, she admitted she pulled the trigger. She feels bad about it. Maybe she didn't mean to. How about I argue she didn't have the intent? And then the second prong, when the jury finds her guilty, it's well-established case law says that that means there was a destruction of accident would not have made a difference, Your Honor. So we'd ask you to deny the motion.
Final word, your motion, and just for the record, the Curtis, People of the State of Michigan versus Curtis Jerome Bird, BYRD, is unpublished, May 10th, 2012, number 301322, and then, just so there's no confusion, I think the record's clear for both counsel, but there's 2 Thomas cases, and the other one is 2 Thomas cases, and the other one is People of the State of Michigan versus Darius Marquise Thomas. It's number 359025, unpublished, August 17th, 2023. I know it's part of the pleadings of both counsel filed, but I'd like to make it easy when the Court of Appeals reads these and wants to look up cases. So you may proceed, counsel.
Yes, I was looking at my notes and I was looking at Thomas and I was like, well, that doesn't make sense. And I was like, it's the wrong Thomas.
That's why I distinguished for the record, for the court reporter and the Court of Appeals, so a lot of cases have same name or similar name, so I like to put the whole thing on there, so
Thank you.
anyways, counsel, you may proceed.
So what I would like to say first is the prosecutor citing Hawthorne, and that was a case where they did acknowledge that it was error to not include the acts instruction, but didn't find prejudice, because I think it was something about the Hawthorne court said that they must have found that Hawthorne had the specific intent of firing the gun because of the element of intent. So without digging deep into Hawthorne, they must have concluded that that was the argument, that Hawthorne had the intent to fire the gun. That's distinguished between Ashley's case and Hawthorne, because for second-degree murder, you don't have to have the intent. You only have to kill. You only have to have the intent to kill, the intent to. Yes,
Okay.
you only have to have the intent to kill or the intent to commit great bodily harm, or the third option, you're creating an unreasonable risk of death or great bodily harm. And that was the sole argument that the prosecutor focused on. The prosecutor is arguing that bringing a gun to a fist fight created an unreasonable risk. And I understand that you can look at all the evidence to prove intent, but was the prosecutor trying to prove intent? Or was the prosecutor trying to prove the third prong? The third option for second-degree murder was creating an unreasonable risk of death or great bodily harm. That's what distinguishes Hawthorne. And that's what makes Hawthorne inapplicable in terms of the prejudice. I cited Hawthorne. It cites the error for failing to request the instruction, but it is off the mark when it comes to prejudice, because the jury, based on the arguments of the prosecutor, if they bought those arguments, didn't have to prove intent. And when you only have to prove this other element, it's a whole different set of facts, and it's a separate analysis on prejudice as to Hawthorne. The other argument that the prosecutor made was, even if Leanne was pulling the gun and she would have pulled it in a downward motion and it wouldn't have fired upwards, well, that's mere speculation. I mean, when there's a struggle over a gun and the adrenaline and two people, the gun could have ended up pointing in any different manner of direction. So I think that argument should be severely discounted. It's mere speculation. It could have been up, down, sideways. Unfortunately, it was a lethal shot. But it was a shot based on the defense from an accident, a tragic accident, which the jury was never allowed to consider. So I think if I could say one more thing.
Sure.
I think the two go hand in hand. When you prejudice, you have to look at the argument as improper argument for the prosecutorial misconduct for arguing against the right to keep and bear arms and the right to the Second Amendment of the state constitution, because that's the linchpin of their whole argument that led to the conviction. So I think the two go hand in hand, and that makes the ineffective doubly worse. And I think you had another.
No.
Okay.
No, we're good. Thank you.
Thank you.
While there is a Second Amendment, the right to bear arms, I don't think that's really the issue here. The issue is, could the jury find the state of mind that she intended to kill, she intended to do great bodily harm to Leanne Hawkins, or she knowingly created a very high risk of death, or create bodily harm knowing that death or such harm would likely be the result of her actions. The jury is free to believe none, part, or all of any person's testimony. If they would not have believed there was an intent, they certainly could have found not guilty. And part of finding not guilty would have been that it was accidental. She didn't mean to kill. She didn't go out there with the intent to do great bodily harm. In fact, the jury did find that she had the intent, or they would have found not guilty. There were no questions, as I recall, that came back asking about what do they do if they find it accidental, or if there was a manslaughter or anything else. There were no questions, as I recall. I'd have to go back. I think there were some questions, but I think they were very clear on what happened and what the testimony was. The fact that she had her finger on the trigger, the fact that she racked the gun, the fact that she didn't just have the weapon or say, hey, I've got a gun, knock it off. She pulled it out. Whether or not there was a fight or not is in regard to the weapon being there. Even if she got hit and struck in the head, I don't recall any testimony where she turned around to see who hit her in the head. She was aiming for one person and one person only. And I'm not going to sit as the 13th juror. If I grant this, then I am telling everyone that the jury's act of finding her guilty was that they did not find the intent. And I would agree with the arguments of the prosecutor and hold them as my own in regard to they found intent. It's either you find intent or not. No intent means they could have presumed it's accidental and found it not guilty, even without the accident instruction. Common sense, we tell them to use their common sense. If they would have found that it was accidental, even without the instruction, we would have ended up with a no intent, therefore accidental, sad situation for everyone. That's not what they found. They did find that there was an unreasonable risk of deadly harm, and if we have a new trial, I do not believe the outcome will be any different. And therefore your motion is denied. I'm not finding that counsel was ineffective. So this matter then certainly can go to the Court of Appeals. They may see it differently. But when I read all of the cases that you all presented, I can't reach any other conclusion. I've tried to see it your way, sir, but when I look at that situation and the trajectory and all the various acts, it just doesn't hold up. So I appreciate the time. You made a very good argument. I simply disagree based on the law and based on the situation that I heard at trial, that I've reread, and that I've heard from all of you. So your motion is denied. Who's preparing the order?
I will prepare the order, Judge. I had a question of clarification.
Yeah.
When you said that the jury found intent, are you specifying intent to kill, intent to create bodily harm, or
by virtue
greater
of
risk of unreasonable?
Well, by virtue of their finding of second degree murder, right? That's an intent crime. They were read the instruction. They found that there was an unreasonable risk of harm there, right?
Well,
Well,
they
we
found
don't
second
know.
degree murder. The jury doesn't pick which intent. They find
They
guilty of
just-
second degree murder. They can
Right.
choose to it.
That's why I asked if you
Yeah.
were making a finding of which of the three that they selected.
No, but I can infer from what they found that they found this was unreasonable. And so I don't know what they based, we didn't talk about that.
Okay.
But I don't think this is going to change regardless if we put them in front of another jury. If we put this case in front of another jury, when I look at the elements, regardless of how they found one of the predicates, and I'm not going to sit and say they didn't, because their finding was consistent with the testimony, regardless of which or section they found, which we don't ask them, so I'm sure I stated that poorly, but there's a number of different options, and so they could have found any one of those, and they clearly found there was an unreasonable risk of deadly harm, and they ruled that way. They could have said not guilty, an accident could have been one of their reasonings just based on common sense. They didn't do that. Because the facts spoke differently. It spoke to one of those predicates in the instruction. Is that clearer?
Yes, thank you very much for that, and I will prepare the order. I'll just say denied for the reasons stated on the
Yeah.
record. The Ginther hearing is obviously denied as well.
Yeah, it's all denied. I think I don't see any grounds upon which to grant this. You know, if I would find that, I'm all about having a new trial if I think there's an error, but I think the jury got it right based on the testimony in the record. And I can't undo the record. So that being said, I don't think there'll be a different outcome, and I'm not going to waste anybody's time. Thank you. That's all.
Thank you for your time and engagement.
Yeah, thank you very much. That's all for the record.
Copy.